Hi, Mike. Welcome to the show.
Hey, Jay, thanks for having me. I appreciate it.
Mike, obviously you have a wealth of knowledge with SSDI workers' comp law, but we wanted you on you today on the show to talk about some of the workers' comp fraud that you could run across.
Okay, thanks. So basically, in a nutshell, that comes up when someone is both collecting a workers' comp check and working at the same time. Okay, it's not to say you can't do both, but you need to report it, and you cannot be collecting what we call total disability if you're working. Because if you're working, you're not totally disabled. You could be partially disabled, and that can be legal, but you have to notify the insurance company, and they have to make the financial adjustment for the wages that you're earning. But if you get caught, and I have had people get caught, the insurance company is usually the first one to turn it over to the fraud unit, and then they can go after you criminally in district or superior court, depending on how much money it is. So it doesn't happen all that often, or if it does, not a lot of them get caught. But when they do get caught, they try to make a big stink about it and try to get publicity on it and everything else so that it doesn't happen again. So they do try to really embarrass you, and they really want you to go to jail just to prevent others from considering doing it.
Right.
It happens, and it doesn't happen as frequently, especially during COVID, because not as many people visibly out working. But once it's back, you'll get people back doing it. They know it's wrong. We advise them it's wrong, but yet they think they can beat the system. And when they get caught, then they're in trouble.
So walk us through a little bit about the investigation. So what if they think that there's something going wrong? Does the investigation happen before the charges essentially get charged? Or how does the process work in terms of that?
So usually what you do, you find like a private investigator who is, sent to follow you. Then they'll interview the employer, find out if you're working. They'll subpoena payroll records. Oh, believe me, they have it cast iron by the time they go to the U.S. Attorney's Office or to the even the Attorney General's office. Or there is a whole division of the Attorney General's office for fraud. And by the time they go there, they have a pretty solid case. It's not something that they're just going on a whim.
So does someone report it? There's usually a whistleblower? How do people find out who to follow? Do they investigate them all?
All right, so the number one whistleblower is the ex-wife or the ex-husband. They are the number one whistleblower. The second the number two whistleblower would be your neighbors.
Oh,
so if you really aggravate your neighbors and you piss them off, and then you talk about the fact that, hey, I'm collecting comp and I'm working, if you're stupid enough to open your own mouth and you tell your neighbors, then that's a good way to get caught. But usually it's ex-wives who are looking for more money in child support or alimony, and they know that you're working under the table and you're collecting comp. They're usually the first ones to report it.
So sometimes does it happen the other way? We're talking about ex-spouses that may not be very happy with them. What if it's like a false allegation? Do you help them walk through that in terms of the investigation to just kind of get them the right information?
Yeah, I mean, the first thing that they do is, so they have what they call an earnings report that they send out like every 6 months. And they ask if you have any earnings, right? And you fill out whether you have earnings or you don't. And there's a box you can check that says, I've had no earnings during this period of time. And then you sign under the penalties of perjury. So they're locking in your own statements before they even, take it anywhere else. Then what usually happens is the insurance company just wants to know how active you are. So they send out a private investigator. Private investigator shows up at your house 5:30 in the morning, stays till like 8, and see if you leave the house. And if you go, where do you go? And they follow you. And if they lose you, don't worry, they'll come back another day and find you again and follow you. A lot of people think that they're smarter, but nowadays they're just not. I mean, between long zoom cameras and videos from across the street, I mean, they can get almost everything. And then when they have it, they'll confront you with it, and you'll know that you're in serious trouble.
I see. Now, as a lawyer, what is your responsibilities about not necessarily reporting this, but how do you, when someone comes to you and you're kind of suspicious that they may not actually have an injury or they can still work, how do you deal with that? What's your tips regarding young attorneys trying to get into this field?
So what I always advise my clients, first of all, you cannot do both. And so don't do both. And I tell them right from the beginning. And what I try to tell them all the time is that, I'm not a doctor. right? So I only go my case is based upon what the doctor tells me. And I'll tell the judge all the time, Judge, I am not the doctor here. I'm just taking the evidence that's given to me by a doctor, and I'm presenting it to you. So if the doctor and the injured worker have worked something out, then the doctor will be in trouble. But I'm not going to get in trouble because I'm not making the statement that he's disabled. I'm simply reading a statement that was given to me from the doctor. So I always try to make that difference clear to the judge, especially if there's some suspicion that it might be going on. I said, Judge, this is what his doctor says. I don't have that capability to make that assessment.
Right. Now, what is the intersection with SSDI? I know you do some of that. So say if a person's, has such a serious workers' comp situation that they can't go back to work at all again.
So, yeah, if they don't go back to work, so the whole standard is to collect Social Security disability. There's no such thing as a partial Social Security disability, although it's a little caveat. I'll explain that to you in just a second. But to qualify, your disability has to last or be expected to last at least 12 months. So basically, in a nutshell, if one of my clients are out a year and they're still not recovered, I tell them they have nothing to lose by applying for Social Security disability because Social Security is in addition to workers' comp. Social Security will take credit for the workers' comp, but workers' comp does not take credit for Social Security. So it's only extra money. And so, like, for example, right now under workers' comp, you can get 60% is the maximum you can get for total disability. But with Social Security, you can actually get 80%. And they do that they take your average current earnings. So they take the last 3 years or the highest 3 years, and they multiply it by 80%. And between workers' comp and Social Security, you can get up to 80%, but not more.
I see. And how long does workers' comp last?
So right now in the state of Massachusetts, it's a little backwards. I'll explain it to you, though. You can collect total disability for up to 3 years. You can collect partial disability, which means either you can work or a judge thinks you can work, or you are working. You can collect that for 5. So with simple math, and even though I'm a lawyer, 3 and 5 is 8. But in Massachusetts, you can only collect what we call temporary benefits for 7 years. So if you collect 3, then you only get 4. If you collect 5, then the most you can get is 2 on the total. So no more than 7 years, and it depends on how you slice it up.
I see. So Mike, when should be people calling you? When is a good time when they're like, I should call Mike Walsh or email him? Give us some idea about that.
So, Jay, the one thing, and I'm probably one of the only attorneys who tell you this, is I only get paid when I win, right? So it costs people nothing out of their pocket for me to represent them or, honestly, for me to talk to them. So, I talked to someone just yesterday who's just starting their case, and I just tell them, what to look out for, things that they should pay attention to, and I tell them, in Massachusetts, they can pay what we call without prejudice for 6 months, up to 6 months. And so during that first 6 months, they might not need me because the insurance company's paying them, they're paying their bills, they think they're going to have a quick recovery. So I tell them, you can call me during that period of time, but I don't necessarily have to do anything. If the insurance company then stops your check, if you come to me then, now I got to get together medical records. I got to put the file together. And so now there's a little bit of delay on that end, which can delay them getting more money or more benefits for like up to 2 to 3 months longer. So it costs nothing to have me. And it's not like if you get me at the end of the 6 months, I charge you less. Or if you get me on day 1, I charge you more. The fee is the same all the way through. Right. So I tell people the earlier you get me involved, at least talk to me, keep me up to speed, and I'll tell you things to look out for and when I think the insurance company is going to change how they're handling your case so that you're just aware of it and know what's happening and what the insurance company and your employer are thinking. So I tell people, call me as early as you can because at least I can give you advice and things to look out for.
And Mike, in terms of industry, have you seen particular industries needing more of your services since the pandemic or before? Was there a particular industry that needs a lot of your help?
So I would say that, look, the number one is probably construction, right? They're doing heavy work all the time. Right. And, if they start at a young age, by the time they're middle-aged, they've done a lot of damage to their back. And if they have an injury, they're probably not going to be able to go back to construction, or if they are, it's going to be in a different fashion.
Right.
That's probably the number one. The second one, believe it or not, is healthcare, because they're always lifting patients, moving patients, helping them up out of wheelchairs, moving them from one bed to the MRI table. And so there's a lot of back issues that come up as a result of the health industry. Probably the third is probably restaurants, or the type of business that's always running. As I like to say, you're running from the kitchen, you're doing dishes, you're slipping on the floor, waitresses, that bartenders. Those are all kind of different areas that probably would be the top three in my estimation, anyway.
Now, does it have to be a physical impairment? Because we talked a lot about physical issues of people in construction or in the food service industry. Can also be like a mental condition that has developed as a result of work.
Yeah, I mean, it clearly it can. It's a higher standard because you kind of have to take people as they are. But right now, it has what happens at work has to be the predominant contributing cause, and it has to be an event or series of events that are outside of what we call the word just went out of my head, but outside of typical raises, being demoted, being fired. You can't bring a claim for that. But I use the classic example, if you're a bank teller and someone comes in to rob the bank and somebody puts a gun in front of you, that's one event, and that's enough to be struggle with, fear and anxiety and depression. That's simply one is enough. It's called a bona fide personnel action. So whatever a bona fide personnel action is. So, if your boss is a real SOB, it kind of gets muddy there, because is that really a bona fide personnel action, right, or is he just being vindictive as opposed to, giving you constructive criticism? And so it's kind of a gray line, and there's lots of litigation on it, but it's, and the case law, honestly, is I have two cases right now that the case law is developing on psychological issues, because it's never been decided, or at least there's no case law on it that's been decided for the issue of you have a psychological issue, you go back to work at some other place, and then the work there causes you to go back into depression or be stressed out. What impact does the second job have, and who should pay, the first insurer or the second insurer when you go back out? Right, in that case, the degree of which it aggravates has never been decided. So I presently have two cases on that same issue, but they haven't gone up yet because the judges, one is on a remand and the second one is still in the middle of trial right now, but they're going to have to be decided at some point.
And I think the important thing to remember is it doesn't cost people to call you. So they should actually call you regarding any type of thing that's preventing them to work, to see if that's something that you can help them with. I think that's such a great thing.
Yeah, and tell them all. And look, and I say this, at all my networking groups, the call is always free. It's always free. Well, I don't send, even when I represent you, I never send you a bill. You'll never see a bill from me. I just pick up the phone and talk to you, just like we're doing right here, and explain it to you, let you make the decision. I love the phrase, and I've used it 100 times, is my best client is my educated client, because then they can make the right decision for them when the time comes. And if they know everything about their case and all the possible outcomes, then they make the decision. I can make a recommendation, but it's still ultimately their decision. So,
well, Mike, thank you for coming on today and educating us about these very important areas of law.
Thank you, Jay. I appreciate you having me, and continue your good work, my friend.
Thank you.
All right. Talk to you.